Hello, you're watching IndianExpress.com. The Supreme Court has quashed the land acquisition by the previous West Bengal government in Chingur, which was meant to be allotted to the Tatas for the nano factory. To discuss the observations of the case, we have with us Utkarsh. So, Utkarsh, what were some of the important observations of the Supreme Court?
Yeah, hi Ankita. See, this is a major verdict by the Supreme Court relating to the process of land acquisition by a state government. Now, in this case, the Supreme Court has held this acquisition of 100,000 acre land in Hooghly Singur to be grossly perverse and illegal. The court held that this acquisition trampled upon various provisions of the Land Acquisition Act and it violated a lot of provisions, and further the court has said that such an acquisition cannot be held tenable in the law. Apart from holding it to be bad in law, the Supreme Court has also ordered that this land has to go back to the farmers or the landowners within 12 weeks from the judgment, and the compensation which has already been given to the farmers cannot be recovered by the state government since they have been deprived of the enjoyment and the fruits of that land for more than 10 years now.
Also, Utkarsh, we understand that two judges on the bench, they differed on public purpose, the whole arena of public purpose in land acquisition. Can you tell us about that?
You see, Justices V. Gopala Gowda and Arun Mishra, they wrote the judgment, reached the same conclusion that the acquisition was bad. However, when the points relating to the public purpose came, they differed with each other. Now, that's a very significant aspect of the land acquisition proceeding. When the West Bengal government tried to acquire the land in 2006, it cited this provision of the Land Acquisition Act that it is being acquired for the public purpose. And however, Justice Gowda said that this land cannot be said to be acquired for public purpose. It was acquired for a company at the instance of the company, and by no stretch of imagination such an acquisition can be held to be good in law. He also said that if we go by the analogy, then every land that will be acquired for the company henceforth could be said to be acquired for public purpose. Now that is why he called it grossly perverse and illegal. However, the other judge on the bench, Justice Arun Mishra, said that because the compensation in this case has been paid by the West Bengal Industrial Development Corporation, which means that because the compensation has been paid out of the public money, which is a test for whether the land is acquired for the public purpose or not, this is a valid acquisition under the ambit of public purpose of the Land Acquisition Act.
All right. Also, Utkarsh, this entire judgment comes as a big victory for Mamata Banerjee. But where does this leave the Tatas? Like, what does it mean for the Tatas? Can you talk a little bit about that?
This is a major victory and a major political triumph for Mamata Banerjee and her party, because after the acquisition, it was she and the party which had led and spearheaded the protest at Singur. Now, when her government came to power in 2011, they also changed their stand in the Supreme Court. They decided not to support this acquisition, and they told the Supreme Court that we want to change our stand because of the non-compliance with the provisions of the law. And now Tata challenged in the court. Tata said that only because a different political party has come to power, it cannot be allowed to change its stand. However, the Supreme Court today supported the state government, the Mamata Banerjee government's contention, and said that if the state government realizes at a later stage that acquisition proceeding was bad in law, it can change its stand. Now, with this victory, while it's a major political victory for Mamata Banerjee, as far as Tatas are concerned, they have a long way to go. In a very measured response, they have said that another petition by Tatas on the Singur Act is still pending in the court. Now, they will be in a position to comment on this case only after the other case is also decided.
Well, it's interesting you mentioned that. So there's this other case that the Tatas are in contention with the state government. What is all that all about?
So let me give you the background of the case. Now there were two cases pending in the Supreme Court. One arose out of the initial acquisition proceeding in 2006. Now in this case, the Calcutta High Court had ruled in favor of the acquisition and Tatas. However, after Mamata Banerjee had come to power, she promulgated the Singur Act, which meant to retrieve land and give it back to the farmers. Now, the Calcutta High Court quashed the Singur Act, which was proposed by the Mamata Banerjee government. Now, this quashing of the Singur Act by the High Court is still pending before the Supreme Court. Now, the Supreme Court is yet to take a call. However, now since the original acquisition proceeding has been held to be bad in law, the later act, which sought to do the same, in my opinion, it would be rendered infructuous.
Thank you, Utkarsh, for decoding that 200-page judgment for us. For all the latest news and updates, stay tuned to IndianExpress.com.